Uh, Good evening, friends. It's always a pleasure to invite a speaker who is well known within these professional circles of law fraternity, judicial circles, not only for his knowledge, but also being the fact that he's an erudite speaker, coupled with the fact that he has written several books. And the fact that it's a working day tomorrow, and people are just joining us on this platform and shortly on the Facebook, shows that people actually want to learn through his process of teaching. The only difference between the title of today is March of Law in the Rent Law, and the month of March is that after March there was a lockdown, but today they will be marching ahead of the thought process. And a rent law, to give an entire gamut, or what we say a bird's eye view, in a short span of around an hour. It's only an art which I'll ask Mr. Balaji after the session or during the session how to learn that nuances to put and hammer the point in the right perspective so that one can understand the entire gamut, how the things have to be placed. Because it's not just the webinar, but this art, ultimately, as we say, even in law, you should know how to funnel the facts coupled with the law. Because you may know the law, but you may not be able to put the points. You may know the facts, but you may not be able to put across the law. But how you have to place them in the right place, right time, is the nuances which definitely one learns with the flux of time and with the willpower to do that. But this is an art which can sometimes be learned by the process of absorbing and observing. So this, after his insights on this topic, and when the question answers will be over, we will ask him to just give a 2-3 minutes talk on this point, and so that the fraternity at large could be enlightened and they would know how to move forward, and they can actually march in the profession. We should not only be marching except for the march of rent law, but also marching in the profession with the nuances to be learned from him. Over to you, Mr. Balaji.
Thank you, Vikas, always for the kind words. But one of my friends in a lighter vein, after seeing the topic, said, we are only in October. Why jump to March already? So I told him, no, I'm going to take a history class as to how the rent legislations evolved around the period of time, especially in the country. And I'll try to put it in a nutshell, as Mr. Vikas said, in a bird's eye view, and what rent control is all about, how the rent control laws have evolved in our country, and what is the road ahead. See, as you all know, the rental sector is a very important player in the economy. But a survey conducted by the United Nations in the late 80s found that more than 42% of people were tenants under somebody. So as we all know, the difference between the haves and the have-nots has always existed. So too, the rental disputes between landlords and tenants. The earliest rent control legislation which we can trace back is to the early 1900s in the United States of America, where after the World War, there was very high demand for rents, and the landlords started exploiting tenants. So the local government felt that there must be some control exercised. So as a wartime measure, Rent Control Act was promulgated even in the United States, in the America. India did not lag far behind. After the Second World War, a similar scenario occurred where landlords took the lead and tried to exploit the demand and scarcity for rent and started demanding very exorbitant rents, and for the mere asking, trying to evict the tenants so that they can give it to new tenants and claim higher rents. So this, the then government, even before independence, under the Defense of India rules, the British government felt that some control must be exercised and that there must be a rent control in place. It was only thought of as a very temporary measure, as a wartime measure, which later the Honorable Supreme Court has commented upon in very number of cases, that it was only a wartime measure, and whether it is still stands the test of the advancement or economic boom that has happened later is a question which we will have to take a call. But most of the states have rent control legislations. As I told you, under the Defense of India rules, the house rent control orders and go down rent control orders were promulgated by the British government in cities like Bombay, Calcutta, and Madras. This was post the Second World War. Slowly, those orders after India attained independence were of no consequence. So the new government, the Indian government, felt that the situation did not improve. Therefore, we still have to continue with the rent control measures, and therefore these various states in the country have gone ahead with the exercise of bringing about rent control legislations. See, why at all rent control legislation, you may ask me. So as I told you, it is for a purpose. It is to prevent unreasonable eviction of tenants. And as the name of the act itself suggests, control of rent, so that the landlord cannot demand an exorbitant rent which the tenant is called upon to pay, forced to pay. So these are the two main objects of any rent control legislation in the country. To prevent unreasonable eviction, and to prevent and to control rent so that parties arrive at a reasonable rent. Different states have different terminologies for the control of rent. They call it standard rent, basic rent, fair rent. But the principle, the common thread in all the rent legislations, the objects are only these: to prevent unreasonable eviction and to control rent between the parties. So therefore, you could imagine that the free right to the parties under the Transfer Property Act was curtailed. So it was a restriction placed on the parties who otherwise would be governed by the provisions of the Transfer Property Act. A lessor and lessee can enter into a contract and they are governed by the Transfer Property Act. But an exception is carved out by rent control legislations all over the country. And as you know, rent and housing is a state domain. It is within the state's domain to pass an act. But being a federal structure, the central government has got power to suggest measures as to how the states should go about their rent control legislations. But we have had very many acts between 1945 and 1960. If you see, most of the rent control legislations are a fallout of the Second World War, where the situation was very grave, demand for accommodation was very scarce, and landlords were exploiting that situation. To lighten the history class, I would probably narrate a small joke. And a very elderly gentleman went to the church and entered the confession box and told the father, I gave accommodation to a World War refugee. If father said, there's nothing wrong, why should you confess? It's not a sin that you have committed. You only helped somebody. Or which the elderly gentleman said, no, father, I collected rent from him every month. That is all right. I would not say it's very reasonable, but it is all right. It's still not a sin. Where did you allow him to reside? Was the next question by the father. The elderly man said, I allowed him to stay in the attic. So even for allowing a person to stay in the attic, the man collected rent every month. So this was the situation which I can explain in a very lighter way. This was actually the situation post Second World War. The landlords, the tenants were at the mercy of the landlords. They did not have a choice. The housing is very important for everybody. A family needs a house, a shelter. A basic shelter is required for a family. A single man also needs a shelter. He may need a room. A family may need a house or a flat. Therefore, this situation was exploited by landlords, which culminated in various rent legislations controlling rent and unreasonable eviction. Now, this happened between 1945 and 1960. For example, the Delhi Rent Control Act is 1958. The Tamil Nadu Rent Control Act is 1960. The Punjab Rent Control, I think, is 1941. So similarly, all acts have their own state enactments, which is an exception carved out from the Transfer Property Act. So what kind of leases come under the rent control laws is the next question. See, all leases do not come where there is a letting of a building. So the predominant necessity for an agreement to come within the purview of the rent legislation is there must be letting of a building. If it is the letting of a vacant site, then it does not come within the purview of the rent control acts. You will have to fall back on the Transfer Property Act and issue a 106 notice and failure to comply with the demand notice, you file a suit for recovery of possession. But where a building is let out, straight away, Transfer of Property Act does not apply. So this is the main feature of any rent control legislation. So a landlord-tenant relationship is what we call a dual relationship between a landlord and tenant. That must be existing for matter to come within the purview of the rent control law. Then there must be a letting of a building. And again here, as you see, there all acts have various exceptions. So even the rent control acts have exceptions. Certain kinds of buildings do not come within the purview of the rent control law. For example, all properties owned by the government. In most of the states, I would say more than 95% of the rent control legislations across India, pan-India, the government properties are exempt from the purview of the Rent Control Act. You may ask me why. See, unlike private players, the government is not interested in increasing the rent or demanding tenants to vacate at their whims and fancies. So therefore, the legislature thought the government tenants under government do not require protection. So this state rent control legislations were only brought about to protect tenants from unreasonable eviction and high demand of rent. Therefore, they thought government tenants under the government do not require such protection, therefore exempted. Then in Tamil Nadu, if you take temples, religious charitable trusts are exempted. Trusts which are registered in the Indian Trust Acts are exempted. Works registered in the Works Act are exempted. There are a lot of exceptions. Similarly, in all other states, you will find there are a number of exceptions which actually defeats the very purpose of the legislation itself. So all those matters will not come within the domain of the Rent Control Act. So there is a disparity. As you all know, any economist, if you ask him a question whether the state needs a rent legislation, his answer will be an affirmative no, a very vehement no. Because economists feel that the economy is ruined because of rent control legislations. It scuttles growth, it scuttles development, it scuttles free market forces to prevail. See, there is demand and supply. Economy is all about demand and supply. So the balanced demand and supply, rent control legislation should go is what most economists across the world have uniformly opined. There is an old lady principle which I would like to talk about here. Let us take a case where a property is coming within the control of a state legislation. For example, Delhi. It's situated in a very posh locality in Connaught Place. It's a 4-bedroom luxurious apartment which was taken over under lease by the head of the family. Family consisted of about 4-5 members, let's assume. The husband passed away 20 years down the line. The children grew wings, they went abroad. The widow was staying alone in that house, a palatial 4-bedroom. Does a single woman require such a palatial apartment in Delhi? But she did not want to let go of the property because there is a control on rent. She will not get a similar accommodation for that particular rent anywhere in the country. So she holds on to the property, which means there is deficiency in availability of actual housing reality market. The rental market is deprived of one property, which otherwise will be opened up for the tenants who are willing. There is a larger family who may be willing to pay higher rent, is deprived of that house because that old lady wants to cling on to the house because she's paying, she's controlled, she's protected under the rent legislation. Therefore, she does not want to let go, vacate the house. So this is one minus point. It's called the old lady principle. This is one minus point. And coming to court, Transfer of Property Act, you need not assign any reason, as you all know. 106 of the Transfer of Property Act, you given 15-day notice, and at the end of the period, if the tenant does not vacate, you are entitled to file a suit for recovery of possession. You need not assign any reason as to why you require the property. But under the rent control legislations, you will have to make out a ground for eviction. So this was being seen as a hurdle for many landlords. Because this was, as I told you, it was only to protect the tenant. So it was only seen as a pro-tenant legislation because it's a wartime temporary measure which has come to stay in most of the states. In fact, only in Tamil Nadu, recently a new act has been promulgated in 2017. The earlier one, if you see, is 1999, where the Karnataka and Maharashtra have brought about new rent laws. The post, that is not the, I would say, probably we can call it the first set of rent legislations was immediately after the Second World War. The second set of legislations were around the late 80s and 90s. Bihar, Karnataka, Maharashtra brought about new legislations. And Tamil Nadu is the forerunner insofar as 2017, where the Tamil Nadu government adopted the Model Tenancy Act, which was suggested by the central government, about which I will come and talk a little later. So what happens under the Rent Control Act is a tenant cannot be evicted for the mere asking. Just because the tenancy period lapsed, a landlord cannot go to court and say, I want my property back. So a concept of a statutory tenancy was created. Normally we know contractual tenancy. A Transfer of Property Act deals with a contractual tenancy. Any contract between the landlord and the tenant is a contract. The lease agreement, the tenancy agreement, whatever you call it, is a contract. So it is governed by the terms of the Contract Act, and it also falls within the purview of the Transfer of Property Act. But when an exception is carved out and you have to come with before the rent control legislation, you cannot ask. The statutory tenant is protected. Once the contract ends, the statute takes over. The statute gives you protection. So the landlord has to make out a case. What are the available grounds for him? See, across various state legislations, these grounds are common. Default in payment of rents. So there must be a default committed by the tenant in payment of rents that will entitle the landlord to seek eviction. Suppose the tenant sublets the property without the consent of the owner, the landlord. That is a ground for eviction. Suppose the tenant misuses the property, he uses it for illegal or immoral purposes, that gives the room for eviction to the landlord. These are punitive provisions. So one set of provisions we can see are punitive provisions, where you seek to punish the tenant for acts or omissions which are not permitted under the Act. Subletting, acts of nuisance, you may cause nuisance to the neighbors or the other occupants of the building, that affords a ground for eviction. Some peculiar grounds which are available in some of the legislations like East Punjab Rent Restriction Act as well as Tamil Nadu Act as ceasing to occupy, where the tenant does not occupy the tenanted premises for a continuous period of a particular 4 months in Tamil Nadu. Similarly, a particular period in the Rent Control Act in the different states, that affords a ground to the landlord to seek eviction on the ground of ceasing to occupy. Denial of title. Denial of title is a ground for eviction in many rent legislations. Suppose the tenant who comes under the comes into the property as a tenant, accepting Mr. X as the landlord, and thereafter he turns around and tries to play mischief and disowns the right of Mr. X and says, no, X is not the owner, X is not my landlord. Such denial, if found to be malified, affords a ground for eviction to the landlord. So these are various punitive provisions where the landlord can approach the court and seek eviction. Then there are other grounds under which the Act empowers the landlord to approach and seek for eviction. For example, owner's occupation. So owner's occupation, demolition and reconstruction, these are two grounds where the landlord comes to court and says, I am in need of my premises. He may be staying in a rented premises or his family may have grown. So what he is currently in accommodation is insufficient. So he may say the property which I have let out 10 years back is a much bigger place. I need requirement of that place. So own use and occupation can be for residential, can be for non-residential also. Similarly, demolition and reconstruction. Some states, there is a provision where an option should be given to the tenant on reconstruction. For example, in Andhra Pradesh. In Andhra Pradesh Buildings Lease and Rent Control Act, there is a specific provision where the landlord approaches the court. He must give the first option of reoccupation to the tenant at the prevailing market rents after the reconstruction is over. Only if the tenant does not choose to exercise that option, he can put up the property in the free market for lease. But whereas most of the states, including Tamil Nadu, they do not have such a restriction. In the case of demolition reconstruction, landlord is free to demolish, reconstruct once he gets the property, and he can let it out to anybody. He can also occupy. So these are grounds where the problem where the control comes in is mere default will not entitle the landlord to eviction. There must be a default which is willful. A requirement for own use, requirement for demolition reconstruction must be bona fide. So words like willful and bona fide were inserted as control measures to protect tenants from unreasonable eviction. So this has been the law all along. Most of the states have stuck with these 1940 to 1960 enactments, except as I told you, Karnataka and Maharashtra have come up with 1909. But still, they are more or less based on the earlier enactments, excepting that they provide a minor leeway for increase in rent. For example, let us take fair rent. In Madras and Punjab rent tax, we call it fair rent. In other states like Delhi, it is called standard rent. Principle is the same. So there is a cap on the rent which the landlord can collect from the tenants. This is called the standard rent or the fair rent. He cannot collect more rent than what is the fair rent. How is the fair rent fixed? Either the landlord or the tenant can approach the rent court, the rent controller, and say that the rent I am paying is very high, fix a lower rent as fair rent. Landlord can approach the rent court and say the rent the tenant is paying is very low, please fix a higher rent. So the fair rent is fixed based on the prevailing market values of rents, for which evidence will have to be let in by the parties, and the amenities provided, the cost of construction, depreciation of the building, all these factors will be put together and a standard rent or a fair rent will be fixed. The disadvantage with this provision is, as I told you, being a wartime temporary measure, there is no provision for enhancing the rent once a fair rent is fixed or a standard rent is fixed, except where there is addition to the property. There are additional amenities provided, or there is an increase in statutory municipal taxes. These are very limited grounds on which alone the landlord can approach the court again and say, please revise the fair rent. In most of the states, once the fair rent or standard rent is fixed, it is for the life of the building. So this started working real hardship to landlords. The fair rent petition was decided in 1965. The fair rent, the landlord was stopped from claiming higher rent even in 2001. This really started working hardships to the tenants. So what the central government felt in 1992, we should do away with all these rent control legislations. Enough protection has been given to tenants. So what the central government did in 1992, we have a federal structure. As you know, the constitution provides a federal structure. Therefore, the central government suggested and requested all the states to come up with their own new rent laws. They suggested a model Tenancy Act in 1992. But none of the states have adopted the suggestion of the central government. They continued with the existing rent laws. By that time, Supreme Court also came down very heavily on some certain provisions like the standard rent and fair rent. They said it is very inequitable for a person to fix a fair rent in 1990 to continue to pay the rent even in 2010. The taxes are going up. The landlord is going to suffer. Property taxes have definitely gone up multifold, but tenant continues to pay the fair rent. And that is the only ground in which he can come back to court and ask for a marginal increase. Still, it will not help him tide over the increase in taxes and surcharges. Therefore, all these Supreme Court said, no more it is a tenant-oriented welfare legislation. You must start looking at it as a balanced legislation interpreted in favor of landlords also. This was the statement which the Supreme Court repeatedly observed in very many cases starting from the late 1980s. So the trend slowly changed. Courts started interpreting the provisions through the eyes of the landlord. So what amounted to misuse, you must see from the eyes of the landlord. What amounted to default, you please see the position of the landlord. Is he dependent on the rent? Is the default willful insofar as the facts and circumstances of the case? So the interpretation of the existing provisions underwent a sea change because of the Honorable Supreme Court's views in very many cases. The bona fide requirement was also watered down. They said, for example, demolition reconstruction, the view of the Supreme Court was the building must be in a precarious position, almost crumbling down. Only then the landlord can ask for demolition reconstruction. Immediate requirement for demolition reconstruction, unless the building is in a so bad condition. But later in 1997, in Vijay Singh's case, the Constitution bench interpreted the earlier P.R. Anson's case and said, no, not required. It is not immediate crumbling down of the building. It is immediate relatable to the requirement of the landlord. So not necessary that the building should fall on the head of the tenant. Landlord did not postpone his eviction petition till the building actually crumbles and falls down on a tenant's head. If he feels that the requirement is immediate, he wants to put the property to better use. There are new development control rules. He can put up additional floors. Economic advantage to the landlord is more. So view all these and then decide the matter. So don't look only at the condition or age of the building to decide. So this has been the change in the approach of the courts also. They have also felt that going a wartime measure, the rent legislation definitely require a review. Therefore, again, what happened in 2015? 2015, the central government suggested a Model Tenancy Act. So the state of Tamil Nadu was the first state and only state so far to have adopted the Model Tenancy Act of 2015. They came up with the Tamil Nadu Regulation of Rights and Responsibilities of Landlords and Tenants Act of 2017, following the Model Tenancy Act of 2015. Since the response from all the states was very poor, the central government promulgated another Model Tenancy Act of 2017. There was no response from any of the other states. By then, the Tamil Nadu Act had been enacted based on the Model Tenancy Act of 2017. They passed an amendment to tweak it to the Model Tenancy Act of 2017. Last year, the Model Tenancy Act of 2019 has been suggested by central government to all the states. So far, none of the states have adopted, but I am told Delhi is deliberating on a new rent law based on the Model Tenancy Act. So what is the shift from the old act to the new act? In the new act, the control is taken away. What was controlled by the statute is now sought to be taken away, and it is only merely regulated. So the act, as the Model Tenancy Act says, it is only a regulation of tenancies. It is not a control exercise by the state. So the concept of statutory tenancy is now wholly taken away, and the concept of contractual tenancy is sought to be implemented in all force. The agreement between the parties is respected, and the parties will be free to fix the rent, fix the period, fix the advance, fix the security deposit, and all these. What happens in the absence of any provisions to the contra, then the act steps in. The Model Tenancy Act suggests not more than 2 months rent should be taken as security deposit. And when, at what point the security deposit should be refunded. These are all, and terms like willful default, bona fide requirement have been totally taken away under the Model Tenancy Act. They only say requirement. They only say default. But there is protection for the tenants where tenants can make up the arrears within a period of 30 days and get the eviction petition dismissed. So the law has also taken note of the new developments where landlord may require the property for change of use. Originally, the property may be situated in a residential zone. Now, because of the new development rules, now the property may fall within the commercial zone. So the landlord can approach the court and say, I am now entitled to convert my property into a hospital or a hotel. So I want my tenant evicted. Now that is a ground for eviction. And similarly, the demolition reconstruction still continues. You can still opt for requirement for demolition reconstruction and seek eviction of the tenant. And there is no cap on the advance to be collected under the old Registration Act because control was sought to be exercised. In most of the acts, not more than 1 month's rent could be retained by the landlord as advance or security deposit. Now that has been removed. Whatever parties agree under the agreement is honored. But if there is no agreement to the contrary, then the security deposit amount can be 3 months. Insofar as the 2017 Model Tenancy Act. But 2019 Model Tenancy Act has reduced it to 2 months. These are various laudable objects which have gone into the Model Tenancy enactments. Most of the states, and none of the states have, in fact, you'll be surprised to know 60 countries all over the globe have rent control legislations. So this problem of landlord-tenant is not common only to India. It is not uncommon. It is all over the globe. 60 countries have rent legislations, and economists all over have voted against rent control because that does not allow the market to survive. There must be a demand and supply. It should be allowed to have a free run. Only then the economy will boost. These are the factors which have gone into the Model Tenancy Act suggested by the central government in 2015, 2017, 2019, except Tamil Nadu. None of the states have followed. So what are the other features which derail the original provisions of the rent control legislations? If you see, there is no concept of fair rent. The fair rent or standard rent does not have a place in the new Model Tenancy Act because they want the economy to re-heal and heal on its own. They don't want to put a cap on the rentals, because that also has its disadvantages. As I told you, the old lady principle, that also has its disadvantages. Putting a cap leads to landlords withdrawing their properties from the rental market. They are afraid they will not get back their properties. They are afraid they will not get returns. Suppose a tenant goes and files a fair rent petition. The returns which the landlord will get will be only about 7 to 9% if it is a residential property. If it is a commercial property, he will get about only 12%, whereas his investment in the house will be much more. So his investment with a view to get money, return on investment, is larger. Therefore, he refrains from giving this property to the rental sector. He does not let it out. He keeps it under lock and key. So there, otherwise these properties will be available in the housing market. Tenants who are willing can take over these properties. So these are disadvantages of rent control legislation also. So the concept of fair rent has been totally taken away under the Model Tenancy Act. There is a cap on security deposit if there is no agreement to the contrary. The terms like willful and bona fide are taken away. The landlord proves his requirement, he is entitled to eviction. And there is also, we have seen that all these rent control legislations, there is especially the very rich tenant lobby, they have in fact challenged the provisions in the Maharashtra Act that went to Supreme Court also. They challenged the amendment which preceded the 99 Maharashtra Rent Control Act. They challenged, saying that we have paid huge pagadi and what we are paying as rent is very low. So if today we are not given any protection under the new law, we will be literally thrown out, and what money we have paid, huge advance amount, huge premiums paid by us, will be lost. So that huge tenant lobby, large tenant lobby in Mumbai and Delhi, they have protested the onset of the new rent legislations. Whereas in Tamil Nadu, there was no such protest. Therefore, the act was brought in very smoothly, and it has repealed the rent control legislation of 1960 in Tamil Nadu. The other states are yet to follow. The other features are, it takes note of the economic development. See, under the old rent legislations, once a property is given to the tenant, the landlord cannot even enter the property except for carrying out repairs. Otherwise, he must seek for eviction of the tenant. Only after he succeeds, he will be able to get into his property. That is the reason why there are landlords who prefer to keep their properties under lock and key, of losing their control of the property, leave alone loss of return on investment, but also losing control of the property to tenants. There's a very popular saying where landlords are fools for wise men, read tenants, to enjoy. So this was the problem with the rent control legislation. So which prompted many landlords across India to prefer keep the houses under lock and key and not let it out in the free market for rent. So all these wanted to be cut short and taken away by the central government as a welfare measure, taking into account that now there is enough sector. The urban area has expanded to the rural areas. The cities have grown. There is enough housing market stock across the border, especially in the extended areas of the cities and towns. Therefore, no longer protection is required for tenants. You allow the economy to grow, heal on its own, is the principle of the Model Tenancy Act. That is, for the object is to respect the contractual terms agreed upon between the landlord and tenant. The Model Tenancy Act also, interestingly, contains 2 or 3 provisions which were totally alien to the earlier rent control legislations in all the states. Suppose the landlord wanted to construct an additional floor in the property, which he could not have even imagined in the earlier rent control legislation. He must have first got back the possession of the property from the tenant, then rebuild or put up an additional floor, or the first floor or the second floor. But under the Model Tenancy Act, the landlord is empowered, entitled to approach the court and say, now the rules have been relaxed. I can put up 2 more floors in the building. You please permit me, let the tenant reside in the ground floor. I would like to exploit the new rules and put up 2 additional floors, the first and second floors, or first floor alone, and put it to economic advantage to me. That is permissible. That is recognized under the new law. Similarly, if there is vacant space, there is vacant space in and around the building, and it is permissible for the landlord to put up a new construction. Suppose a 10-ground property was let out to a tenant. The house is situated in one corner of the property, covering about 1 ground. So 9 grounds is vacant. The tenant was paying rent for the house and the upper tenant land. But now if the landlord is allowed to exploit the vacant 9 grounds land, he would definitely get much higher rents, much higher returns on the investment he originally made on his property. That is now given predominance. A landlord can seek for an order from the rent court and say that I want to put up construction in the vacant space, to please permit me. So that is possible under the new Tenancy Act, which is suggested by the central government. And also the period of disposal of cases. Now it is thought to be time bound. The courts, we all know that rent control matters are fought very hard, especially where tenants are very affluent. They take up the matters up to the High Court definitely, and some tenants go even up to the Supreme Court. In this period, 40 years, 30 years is lost. The poor landlord who originally files the case, he may not be alive to see the property coming back to his second generation, not even the immediate generation. There are cases where the third generation succeeded, got back the property. So here that is now sought to be taken care of, where the proceedings are time bound. Under the Model Tenancy Acts, the proceedings are to be concluded within a period of 90 days. The eviction proceedings, the appeal proceedings are to be concluded within 120 days. And of course, the tribunals and courts are given the power to adjourn the matter on reasonable cause shown by any of the parties. So, but at least there is one forward movement. There is at least something to say that the case should be over within a particular period of time, which was not in existence in the earlier rent control legislations, which was taken advantage of by tenants, and unnecessary adjournments were asked, and for years together matters were dragged. And Supreme Court in fact came down very heavily on such tenants, where 40 years, 30 years tenants unsuccessfully canvassed eviction orders before the Honorable Supreme Court. They were asked to be thrown out the same day and reported back to the Honorable Supreme Court with the help of the police. Or in other cases, Supreme Court said you pay double the rent for the time they have dragged the matter from the date of the eviction order, and unnecessarily dragged the matter. The courts are also burdened with their own cases, not only rent control matters which are being decided by the courts. So courts are also burdened with other matters. So we'll have to give leverage to all that also. But at least there is a positive move by the legislature to ensure that proceedings are completed in a speedy and quick manner, which will benefit persons who come to court. There is another feature which gives protection to the tenants. As I said, it's only regulation, not a pro-landlord legislation. There are provisions which regulate the tenancy where the agreement is silent. The landlord may disrupt or interfere with the amenities enjoyed by the tenant, or the tenant will be prompt in payment of rent. Just to create a ground for eviction, landlord may refuse to receive rent. So these are cases where the Act comes to the rescue of the tenant. Tenant can in such cases deposit the rent with the authority who is named under the Act. It used to be the court under the rent control legislations. Under the Model Tenancy Act, it is a separate rent authority who is in charge of deposit of rents by the tenant. He will pass an order if he finds that the landlord has refused to receive 2 months rent consecutively for 2 months, rent for consecutive period of 2 months. He can order the tenant to deposit rents into with the authority. Similarly, if there is a disruption of electricity or water supply or a light amenity in the passage, the tenant can approach the rent authority and seek for restoration. So these are cases where the tenant can approach the rent authority. And unlike the earlier rent legislations, it is usually an original petition, an appeal, a revision to the High Court, an SLP to the Supreme Court. So four rounds of litigation were permissible in most of the rent legislations. But under the new Rent Model Tenancy Act suggested by the central government, it is only 2-tier. The eviction petitions are always filed before the rent court. The rent authority is more administrative. It takes care of registration of the agreement between the parties, uploading the agreement in the website, and the judicial functions are only the deposit of rents order and restoration of amenities. These are the 2 judicial functions which the rent authority performs. But any eviction action will always be before the rent court, which has to be concluded within 90 days. The rent court, once an order is passed, an appeal lies to the rent tribunal. The rent tribunal has to decide the appeal within 120 days. The order of the rent tribunal is made final. It's not subject to any appeal or revision. So a full stop is sought to be put to the litigation so that there is a real purpose of the Act being successful. So full stop is sought to be put by fixing a time period. And there is, of course, there may be an argument that why not a writ petition? There are orders of tribunals which can be challenged by way of 226 writ petitions. Why not this? This came up before the Honorable Supreme Court even in 1968, where a similar provision in the Delhi Rent Control Act makes orders of the appellate court final. So that was challenged and said Supreme Court said nothing doing. Final is final. We cannot entertain any further appeal or revision against that. That was because it is the Act itself provides a summary procedure, and it's a self-contained code. Even the new Tenancy Act, as well as the old Rent Control Acts, all across India, they were all self-contained codes. They had their own procedure. They did not fall back on the general law CPC. They were guided by their own procedure. Even under the Model Tenancy Act, the Rent Court and the Rent Tribunal, they have the power to fix their own, they prescribe their own procedure as feasible to come to a conclusion in the interest of the parties. So this is what the new act is all about. And this act, as I told you, except Tamil Nadu, none of the other states have, in fact, even taken any step forward to implement the new act. But whereas in Tamil Nadu 2017, the act was brought into force, it was not given effect to. But in the meantime, as I told you, 2017 Model Tenancy Act had come into force. Therefore, the act was amended in 2018 to make minor adjustments to come in line with the Model Tenancy Act of 2017, and the act has come to stay. Proceedings are initiated, and we have seen some really good progress where the rent courts who have been designated are giving importance to these matters, considering that they are time-bound matters. The act itself stipulates time periods. Therefore, importance is given to matters under the new act. It is a step in the right direction. So I think this is the march of the rent law in the country, and more or less all the states, as I said, the common thread is, say, one or two states may have exceptions, may be different. The exceptions given to the application of Rent Control Act may be different, but more or less this is the general lay of all the rent legislations in the state. And what we are looking ahead is the Model Tenancy Act, which very soon the states are going to adopt. So I think I'm done with the talking part, and question and answer session may be open.
They say when you are sharing the knowledge, it can never be talking, it can only be learning. And lawyers, while talking, they also earn. In a lighter vein, since when we connected last time, it is said that a lawyer and a doctor were meeting in a party. And the doctor said that he's quite troubled that everybody asks him the consultation so that they don't have to give the consultation charges during the while they visit him in the hospital. So the lawyer advises him the best way is you should shoot out a bill to him on the ground that he has taken an extraordinary advice during the marriage. The doctor says, I'm highly obliged. But after 2 days, he receives the bill for the extraordinary advice he took during the marriage while disturbing the lawyer from being entertained.
So my bill will be to Mr. Vikas.
That's true. So it is by fortuitously, he's also Vikas. He says on a rented house, owner of a property filed eviction case by making party husband on whose name rent agreement was made. But husband left the rented house within 1 month after a rent agreement, and wife is not evicting the rented house and not paying rent. What remedy would be available as the husband is not residing in the rented accommodation?
Yes, most of these state acts, they include members of the family as part of the tenant. It is not necessary that each and every member of the family must sign the tenancy agreement. Suppose the head of the family, the husband takes the house on rent, he signs the tenancy agreement. The term tenant will include his wife and children. Therefore, the landlord is still entitled to approach the rent court if there is non-payment of rent or if he requires the property. Of course, he has to make the tenant, the husband, as a party. Additionally, because of peculiar facts of this case, it is advisable to implead the wife also as one of the respondents. So he is safe.
This is by Abhishek Sharma. What if old lady claimed the property but no family is there to claim body of the old lady? Abhishek, you will have to reframe your question.
Old lady is a landlord or a tenant?
No, the question is not exactly forthcoming. It says by Abhishek, next question is, any views about the recent Supreme Court judgment under the Tenancy Act and the lockdown during the force majeure?
The Supreme Court, in fact, they just dismissed the plea of the lawyers, even in the mentioning stage. So lawyers wanted waiver of rent during lockdown. But the Delhi Division Bench has said the force majeure clause will not apply to rent matters because there must be a surrender of the lease to ask for invocation of force majeure under the provisions of Transfer of Property Act. So tenant must offer to surrender lease. If he wants to continue, he cannot take advantage of force majeure clause and ask the tenant to ask the landlord to waive rents. But Delhi Division Bench has taken a very categorical view that there is no waiver for rental matters, rental agreements. Tenants have to pay even during lockdown.
This is by Radhashyam Maurya. What is the subtle difference between lease agreement and tenancy laws? Are there any distinctions?
So lease, you see, there are different terminologies which parties choose to give. You can call it a rental agreement, you can call it a tenancy agreement, you can call it a lease agreement. Where the problem arises is it is a leave and license. If you term it as a leave and license agreement or merely a license agreement, that is where the problem will crop up. This issue has in fact gone up to the corridors of the Honorable Supreme Court also. What an agreement styled as a leave and license agreement is actually a lease agreement. A building is let out, it clearly falls within the domain of the rent control legislation. But the tenancy, unfortunately, the nomenclature was leave and license. The Supreme Court said nothing doing. You cannot go by the nomenclature given by the parties. You look into the terms of the agreement. If there is a letting of building, if there is a payment of rent contemplated every month, and control of the property is with the tenant and not the landlord, it cannot be a leave and license agreement. It will be a lease agreement only. It will be governed only by the provisions of the Rent Act. So this is the categorical pronouncement of all the courts. So nomenclature is not very important. The object is what you must see is what is let out. Is it vacant land or is it building? Or is it vacant land with even small building, the Act will apply.
This is by Sinithun Murugan. Existing tenant, how to approach the tenant rent court without any agreement in the modern law?
This is one gray area where we are also finding it difficult. See, there is actually no provision which enables the tenant to approach the rent court under the new Act. Approaching the rent court is always the prerogative of the landlord. The tenant can only approach the rent authority. He definitely can approach the rent authority without an agreement. This is where the Bombay lobby felt very left out. They said we are old tenants. Our protection is totally taken away. There is nothing to continue to protect us. Whereas this system of pagadi, which all over India is very common, very huge premium is paid by tenants. Rent fixed is very low. The monthly compensation is very low because they paid a huge amount as pagadi or premium. So the Bombay lobby is still fighting that the new Act should not come into force.
This is what is Pawan? What is the consequence of not having any rent law following Model Tenancy Act? Is TP Act protection not sufficient?
TP Act does not protect the tenant, sir. TP Act, there is 106 notice is invoked. Tenant does not have any ground. Even earlier, before TP Act was amended, at least he had one defense. He can say that notice was not proper. Even after the amendment to 106, even that is taken away. Even if the notice is insufficient or not in consonance with the provisions of the Act, it will not matter. That is the scheme, that is the letter and spirit of the amendment to 106. Therefore, there is absolutely no protection. Protection was carved out in the form of rent control legislations. That is all. Now that control also is slowly taken away and benefit is given to landlords.
Since we are a lot of time referring to section 106 of TPA, would you just elaborate for the young lawyers and students of law?
Yes. See, any lease is defined under the Transfer Property Act. Any lease agreement between the lessor and lessee, the owner and the tenant, is always governed by the Transfer Property Act. The only exception is the rent control legislations, which are much later. You all know that TP Act came into existence in 1882. So any agreement can be terminated only in terms of the provisions of the Transfer Property Act. The 106 of the TP Act postulates how a lease can be terminated. If the landlord wants to terminate a lease, he has to call upon the tenant, give 15 days clear notice to the tenant, and serve the notice in accordance with the provisions of the Act. And unless this notice is proper, suppose for example, a notice is given on the 14th of the month and the termination is by the end of the same month. The notice is served on the tenant only on, say, 18th. There is no clear 15 days. The courts have dismissed the eviction petitions on that ground. But now the Act has been amended. So irregularity in issuance of notice is not a ground for the tenant. So as long as that period is given, waited over. Suppose the tenant is called upon to vacate by end of August. The case is filed only in September or October. The court says it is cured. He has got the benefit of that 15 days. Therefore, that the defect in the notice is also not now available as a defense to the tenant. So once the notice is issued, the landlord can straight away approach the court and say, I have issued this statutory notice. There is no reply, or there's a reply with false allegations, baseless allegations. I want my property back. Tenant has to vacate. So the only benefit he will have is the benefit of judicial time. Suppose the backlog is very heavy in that particular court, he will have the benefit of, say, 1 year, 1.5 years, 2 years, or 3 years. But otherwise, he has no defense. So this is the scheme of 106.
According to you, at the most, it will be depending that he will be on a ventilator. It depends how long he can survive.
Right.
And since one had posted what is the subtle difference between lease agreement and a tenancy, there's a judgment of the Punjab Haryana High Court, State Bank of India versus SB Associates by Justice Wazifdar, that they can always examine that. This is by Praveen Kumar. Sir, can owner of a tenant file eviction directly in civil court?
No, he cannot, because all the rent control legislation being special enactments, they bar the jurisdiction of the civil court. So you can approach only the rent court under the Act. Jurisdiction of civil court is clearly barred. Unless you fall under any of the exceptions provided. There, in fact, I hear one of the exceptions you would see is many states have an exception for newly constructed buildings. But Delhi has, I think, 10 years. And Tamil Nadu has 5 years. And I think East Punjab has like 7 years. So they have different periods of ranging from 5 years to 10 years. The purpose of this purpose of this exception was for the landlord who invests very heavily in buying the property, putting up construction, additional money is spent, and to burden him with very low return on such investment is not proper. So therefore, this exception was carved out and a moratorium period was given in most of the rental acts. So for a new building, say 4 years or 3 years, most of the rent legislation would not apply. So you will have to fall back on the provisions of TPA.
Sometimes the landlord takes the benefit as to he has not got the completion certificate. Then he wants to buy it. Then he says that he falls within that exception clause. This is by Rajveer. If tenants decided to terminate the agreement forthwith during the lockdown, but handed over the possession after 2 months, would they still be liable to pay the rent?
That is again factual. I think it has to be decided on facts. See, there are provisions in all the enactments where you can hand over the key to the accommodation controller. Under the old rent legislations, there is an accommodation controller who is a state authority, like the rent authority. You can always approach him and hand over the key, or send the key to the landlord. See, you keeping the money in your bank and say that I paid rent is not proper. Therefore, there must be a bona fide attempt to hand over the keys, thereby possession. So it will again boil down to facts. So if the tenant is able to show his bona fides, then courts may probably take a lenient view and say there has been a bona fide attempt to hand over the key as soon as he vacated. Therefore, he need not pay rent. There is no straitjacket formula which can be adopted for this question.
So, principally, you mean to say that what we say in law is that judgments are not statutes, but statutes are statutes which have to be interpreted stricto sensu in accordance.
That's all.
Mr. Armstrong is so impressed that he says that he requires your mobile number. So you can just post your mobile number, or I will post it. This is by Abhishek Sharma. Suppose an old lady was living in an old house property alone when she died. Nobody was there for funeral in neighbors, did her last funeral rites. And later, two different families living nearby claimed that she was a relative, hence the property should be theirs in this scenario. Or to prove who is the real owner and predecessor of that old lady.
See, as I told you, the tenant's definition is set out in most of the rent acts. In fact, the earlier rent control legislations, which are the acts which came into between 1945 and 1960, member of family had also been taken into account. Who were members of the family? So, in case of residential properties, persons who are residing with the tenant are alone entitled to continue. So, this straight away answers this question. A stranger cannot simply enter the property and say, I am a relative, I can occupy this property. He must show that he was living with the tenant. In the case of a non-residential premises, he must establish that he was associated with the business. So unless he proves, he will not be entitled to continue. So otherwise, the landlord is entitled to take over the property following the due process of law. The change brought about under the Model Tenancy Act is it clearly defines inheritability of tenancy. What happens if the tenant dies? Who are the persons who succeed? It is the spouse and the children first. If there are no spouse or no children, then the parents or father, mother, either of them or both parents. There's no question of a third party claiming right of tenancy under the Model Tenancy Act.
This is by if lease deed is not registered under the new act, whether application for eviction would be maintainable.
This is again the problem we had in numbering cases, because as I told you, the first state to adopt, the only state to adopt so far is Tamil Nadu. So in Chennai, we had a big problem, number of cases filed because the old act had been repealed. So none of the landlords could approach for eviction invoking the provisions of the old act. Under the new act, hundreds of eviction petitions were filed, but the registry kept on returning saying your tenancy agreement is not registered. Therefore, you will not be in a position to number your eviction petition. So this matter went up to the Honorable High Court in a 227 case. So I was fortunate to be part of. I argued the matter on behalf of the landlord. The reported judgment where the Honorable High Court said even divorce registration under the Act as required under the Act, the landlord can invoke the statutory provisions and seek recovery of possession. A simple example I would give you is there is a tenant who defaults. He is not paying rent for 18 months. I am the landlord. I want to get him evicted. It would be stupid of the authority to expect me to enter into an agreement with the defaulter for 18 months. I would be a fool to give him a new lease of life by giving him a fresh agreement. He is already in arrears of lakhs. So it is not in the interest of the landlord to enter into an agreement, because any agreement contemplates a period. So if I want to register the tenancy agreement, it has to be for a period. So tenant will bargain for not less than 11 months. So I am going to invite further trouble, 11 months non-payment of rent. So this is one point I canvassed before the Honorable Judge. The second was, tenants may not be willing. Tenants may want to silently walk away and take the loopholes in the law. So they are going to say once the eviction petition is numbered, tenancy is not registered, therefore dismiss the eviction petition. So these are gray areas which tenants can take advantage. Equally, landlords also can take advantage. This is what the Bombay Tenants Association took up the matter. They said, we have no protection. The landlord straight away demand a rent. We cannot afford to pay that rent because we have already paid huge buckety and we are paying very paltry sum as rent. Today, to dance to the tunes of the landlord, it's not possible for us. We will be thrown out for the mere asking. So these are areas where there is going to be a lot of, I think, the court's interference in the coming years. And Madras High Court will be the first because the Act has already come into force and matters will go to the Supreme Court. We'll have to see how the courts are going to interpret these provisions. But the fact that the Act itself contemplates that there is a ground for eviction for failure to enter into a tenancy agreement. So that itself is a ground for eviction. So when the Act itself contemplates a scenario where there is no agreement, so there is no harm in allowing a landlord to invoke the available grounds for eviction. That is the view taken by the Madras High Court.
One question which generally boils down in the mind of a common person is that why do we have a lease of 11 months?
That is to avoid registration. Even a number of lawyers have asked me, but I think after the new Act comes into play, this may not have any, because any agreement requires to be registered under the Model Tenancy Act. So there must be transparency. So government also wants to know what properties are owned by landlords, citizens of the country, what is the income they are deriving from the properties. So this is also one of the objects, which the hidden objects of bringing in the Model Tenancy Act. The central government will have a very transparent view of the housing situation in the country. What the number of tenants will be paying 5,000 by check, 3,000 by cash. Only the 5,000 will be accounted. So therefore, the purpose of the 11-month lease agreement was under the Registration Act Section 17, any agreement exceeding a period of 12 months and above is compulsory registrable. Section 17 of the Registration Act. The Tamil Nadu government has amended and they has taken away that also. Any lease agreement has to be registered. It dehors the period of Section 17. In fact, Section 49, if you see, of the Registration Act, there is an exception carved out. Any lease exceeding period of 1 year is compulsory registrable, and any agreement of sale is compulsory registrable, provided it falls under Section 17(1) or 17(2). 49 carves out an exception and says, in a suit for specific performance, an agreement of sale need not be registered. An unregistered agreement can be looked into, is what the provision itself says. Similarly, Section 49 says the lease is required to be registered under the Registration Act, that is Section 17, or the provisions of the Transfer Property Act. Then the lease has to be registered. No exception is given except for collateral purposes, as we all know. The agreement can be looked into only for collateral purposes. So only to avoid this 11 months lease started entered into between the parties. So probably very advocates brain which has resulted in this 11 months lease agreement.
In this,
get over the requirement of registration.
In this, I'm just reminded, they said in the lawyers, they used to say that where there's a law, there is a flaw. And where there's a flaw, there has to be a lawyer. And in this case of Mr. P.B. Balaji.
The big circle.
This is lease agreement cases. In which case do we, in which court do we invoke the jurisdiction?
Lease?
Lease agreement cases, where do we invoke our jurisdiction?
So the lease agreement, if it is the lease of a building, it is only the state rent legislation. If it is a Rent Control Act or the new Tenancy Act, you go under the Act. If the authority is prescribed under the Act, the rent court, which is the first court where you seek eviction. For other ancillary relief like deposit of rents, restoration of amenities, the rent authority. Under the old Act is the rent controller who decided all these matters. Not only eviction, but also deposit of rents, disruption of amenity, disconnection of water supply, electricity supply. Every application will go before the rent controller. If there is no lease of building involved, it is only a lease of land, then the civil court will be the proper court.
Mr. Radhesham has clarified he was asking in respect of an agricultural land.
Agricultural land, you will have to go only to the civil court. Or if there is any tribunal, if or any special tribunal constituted for the agricultural tenancies. There are various state laws which provide for special tribunals constituted. So if there is a tribunal available, you go there. You cannot come under the rent law. Agricultural tenancies will not come. Even under the Model Tenancy Act, it is only buildings which are situated within urban areas. The rural areas are exempted. So municipalities, towns, cities, all these buildings alone will fall within the jurisdiction of the Rent Act, even the old Act as well as the new Act. The rural panchayat properties or agricultural leases will not fall within the domain of the jurisdiction of Rent Control Acts.
So the last question by Galaxy: can court compel the tenant to pay the arrears of rent during the eviction proceedings under the new Act?
Under the new Act, yes, there is a provision. Under the Model Tenancy Act, there is a provision where the landlord can, at any stage of the proceeding, ask for an order to be passed directing the tenant to pay the entire arrears. So he can pay, there will be a decree. Decree is executable. So execution is also made very simple under the new Act, which I failed to mention. Execution, you need not fall back on the very laborious process set out in Order 21. The execution is summary in nature. Execution proceedings have to be disposed of within 30 days from the date of filing of the eviction petition. Therefore, even there, the legislature in its wisdom has come to the aid of landlords to get back their properties in quick, reasonable time. So they need not fall back on the provisions of CPC. the provisions, the modes of execution are set out in the Model Tenancy Act. You can attach properties of the tenant, sell properties of tenant, freeze bank accounts of tenants for arrears of rent. So, but one distinguishing feature is I found was, I don't know about other states, in Tamil Nadu Rent Control Act, we had a provision where same question, there is a tenant who is in arrears pending eviction proceedings. A landlord can invoke section 11 and ask for stopping the proceedings itself. It's a shortcut for getting the main order of eviction. The court will order the tenant to pay the entire arrears of rent within a particular time. If that order is complied with, the main proceedings will continue. If the order is not complied with, the main proceedings will be stopped and straight away an order of eviction will be passed. But this proceeding is not incorporated in the Model Tenancy Act. It is like an interim decree. You can get an order for arrears, but you have to execute it as an interim decree. You cannot stop the main eviction proceedings and claim it as deemed to be over, unlike the old Act.
Thank you, Mr. Balaji. As it's said,
one question on court fees.
Yeah.
Court fees, yes, most of the rent legislations, as I told you, were 1949, 1958, 1960, where the court fees was very, very minimal. For eviction petitions, used to be 15 rupees or 5 rupees for deposit of rents, 5 rupees, 15 rupees for owner's occupation, 10 rupees for willful default. This was the prescribed fee. But now, with the coming into the new Act, the Court Fees Act, Section 43 is made applicable to the Model Tenancy Acts, which is suggested by the, so therefore, the court fee payable for landlord-tenant disputes under the Court Fees Act, Section 43 is now made applicable, which means you have to pay 3%. At least in Tamil Nadu, it is 3%. It will depend on state to state. It was 7.5%. Now it has been amended to 3%. So you will have to pay the value, the fixed court fee, fixed under your specific, your relevant state acts, on the 1 year's rent following the eviction petition. Suppose you are filing the eviction petition in, say, December 2020. You will have to calculate 1 year's rent, which is payable from December 20 to November 2021. A total of that rent into the percentage provided under your respective Court Fees Act is the court fee payable.
Yes. So, Mr. Balaji, we are quite delighted the way you expressed the march of law. I can always vouch that people will actually be marching in their mindset, because a lot of doubts which could have been there or which were there stands dispelled with. The cobwebs within the mind are now clear, and they would be able to shape and think in the right perspective as to how to advise the clients. So tomorrow, in the pursuit of the webinars, we will be having void orders or transactions where they need to be challenged, a critical analysis by Mr. Esteemed Pandya, senior advocate and a former president of the Gujarat Bar Association, at 4 p.m. And those who have been connected with Beyond Law CLC know that Mr. Pandya has, just like Mr. Balaji, though he has given 2 sessions, he has given around 4 sessions, and they have been all well received. So do stay connected to all the participants who have been watching us live on the Facebook, as well as on this platform, and subsequently who will watch us on the YouTube. Everyone stay safe, stay blessed, and keep sharing the knowledge amongst yourself. Namaskar, and thank you everyone once again.